budget concerns are always important, particularly with respect to intellectual property, because IP costs can be very high, and you really need to have a much more active management role when you're thinking about your costs. I think the economy has forced people to really think more carefully about, rather than just setting aside money for IP, think about what is it exactly that we're getting, and then putting the money into the types of IP coverage that make the most sense for the enterprise. One of the things I'm seeing is that people are increasingly looking at the different types of intellectual property that's available beyond just utility patents, which includes design patents, sui generis rights, things like that. And the other thing that people are doing more is they're actively categorizing their own intellectual property into IP that's could be licensed versus IP that's in a commercial product they have now or a future product, and then IP that really now is no longer relevant to them, and they're sort of performing a triage. And that can be a little hard, because sometimes people feel like, wow, I've already paid all this money into this piece of IP and now I'm going to kill it. But the reality is, from a business perspective, if you're not using it and you can't license it or use it to somehow benefit the business, it doesn't really make sense to continue to pay for it. And I think people are having those more difficult conversations more frequently these days. Well, I think that 2009 was a big year for us in intellectual property cases. Certainly a lot of them impacted how practitioners like me will approach going forward with representing our clients in the patent office. But the ones I think that really resonated the most with the actual companies is the Bilski case, which is a case that's currently in front of the Supreme Court now. The original claims of the case were directed to an algorithm for determining commodities, and the Federal Circuit said that the claims weren't patentable subject matter, and they put in a new test for, essentially for software, saying that they had to have machine or transformation. And this caused a big scramble in the IP community while we tried to figure out, do we need machine and transformation, or you know, can we get by with something different? And right now it's on appeal to the Supreme Court, and we're all waiting to see what happens. As a practical matter, the machine transformation test is really similar to what's required in Europe, so most cases are probably going to include that language anyway. It's just a matter of how we strategize the claims in the U.S. But there are some concerns that the ramifications for areas like medical diagnostics would be quite burdensome, and so we definitely don't want to lose our edge in some of these emerging technologies and healthcare and things like that with a change in the law. So it's going to be, that's the one to watch for this year. The other thing that has been of increased concern for companies from the cases that were coming out last year is we've got a new version of a patent troll. It was always the non-practicing entity who would go out and sue somebody for practicing a patent when they didn't actually practice it, and it was sort of considered hijacking legitimate companies who are creating products and doing good things for society, using patents in a way that some people would say they weren't intended to be using. But now they've got this new version of the troll, which are these people that go after companies that are marking their products with their patent number, and the patent's expired, or maybe the patent shouldn't have been on there. The big one really seems to be the expired patents, because it's easy to pick up a product, look at it, see a patent number, figure out the expiration date, and then sue the person. And there's a statutory damage of up to $500 per item, and so it's potentially huge. Right now it looks like the courts are not amused with the litigation strategy, so far the judgments we're seeing are actually pretty low, but we've had a huge uptick in the number of cases. Even in the first quarter of this year, I think we exceeded first quarter 2010 probably by double the number of cases that were on file last year. So that's going to be something that people are going to be watching. However, we don't recommend people get rid of their marking programs with their products. We just recommend that they come up with a strategy to make sure that they can make a reasonable case that they aren't marking inappropriately. So.